Does Scottish law or New York law apply in a breach of contract claim involving a Scottish and American company? To find out, you have to read Eccles versus Shamrock, but it's 28 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Eccles versus Shamrock. The citation for this case is 2024 New York Slip Opinion 02841, published by the Court of Appeals on May 23rd of 2024. The issue in this case is whether Scottish law or New York law applies in a claim of breach of fiduciary duty to shareholders, which is an internal affairs issue for a Scottish corporation when the claim is filed in New York. To understand and appreciate the context of this case, I think the helpful background to know is that there's a concept called choice of laws. So a claim can be brought in New York courts even if the incident occurred in a different state or a different country in the world, theoretically, as long as there's appropriate jurisdiction. But with respect to choice of law, the question is which law applies, the law of the state of New York or the law of the jurisdiction that's involved in the matter. The general rule for that choice of laws question is there's a procedural and substantive division. For procedural questions, you apply the law of the forum state, which is New York. But for substantive issues, you would apply the law of the jurisdiction with the most significant relationship to the dispute. So, in contracts cases, the courts have applied what's called a center of gravity or grouping of contacts test to determine which jurisdiction has the most significant relationship, whether it's New York or the foreign jurisdiction. In a torts case, courts would ask which forum has the greatest policy interest in the outcome of the dispute in light of the parties' contacts with each forum. But here's the interesting part for this case. In cases related to the internal affairs of a corporation, the general approach is to apply the law of the state of incorporation. There are limited exceptions. So the question the courts have to ask is, where's the corporation incorporated? And if it's an internal affairs issue, you apply the substantive law of that state or country where it was incorporated. Okay, what are the facts here? This is a case about a company called FanDuel, which is a sports betting company. In 2007, a company founded in Scotland called Hubdub was founded as a company that allowed betting on current events, but it soon afterward became a sports betting company and became FanDuel. In 2009, FanDuel expanded into the American fantasy sports betting market, and in 2011, it established headquarters here in New York. In 2015, FanDuel's principal competitor was another company called DraftKings. And they were extensive competitors. They had a very expensive marketing war against each other. And they eventually agreed to a merger to combine forces. The deals of the merger were that each company's shareholders would get half of the equity of the firm. And there were multiple classes of shareholders. Ultimately, that deal fell apart because of regulators and challenges and antitrust issues. But at that point, right after the deal fell apart, FanDuel's board, the board of directors, changed its articles of incorporation, collapsing its multiple classes of shareholders, into two classes, preferred shares and ordinary shares. And basically, it resolved that in the event the company wound down in another merger, if they tried to do it again, the preferred shareholders would get compensated first. And if there's anything left, then the ordinary shareholders would get compensated. In May of 2018, FanDuel again voted for a merger. The value of the preferred stocks at that point were for $559 million. The merger agreement included that FanDuel would get $465 million, which is less than $559 million. So since it's less than the amount that the preferred shareholders would get, none of the money, $0, went to the ordinary shareholders. All the money went to the preferred shareholders. At that point, 100 ordinary shareholders who got nothing but owned approximately 10% of the shares sued the defendants under New York law. They claim that the defendants, the preferred shareholders and the different corporate defendants, deliberately undervalued FanDuel's value and assets, breached the fiduciary duty to the ordinary shareholders, failed to obtain a fair valuation of the merged company, and imposed a depressed valuation in order to enrich the preferred shareholders at the expense of the ordinary shareholders. At that point, the defendants moved to dismiss for failure to state a cause of action, and they claim that under the internal affairs doctrine, Scots law applies, and under Scots law, this claim is not cognizable. There is no duty to the ordinary shareholders under Scots law. So plaintiff opposed. It goes to the Supreme Court, grants the motion to dismiss some of the causes of action, and ultimately goes to the Appellate Division. They reverse and grant some of the defendant's motions. It goes to the Court of Appeals, and here they have to confront the choice of law question. And they say, this is what they hold, consistent with their precedent. They say, we clarify that the substantive law of a company's place of incorporation presumptively applies to causes of action arising from internal affairs. So they reaffirm the internal affairs general rule that it's the place of incorporation. They say, because of the important interest of the internal affair doctrine, we decline to create any broad exceptions to the presumption. But they say, in order to overcome the presumption, they establish the applicability of New York law. A party must demonstrate two things, both. Number one, that the interest of the place of incorporation is minimal, which means that the company has virtually no contact with the location of incorporation, other than its fact of incorporation. And two, that New York has a dominant interest in applying its own substantive law. So here they then apply that rule. They say the general rule is place of incorporation unless the plaintiff can prove, or the plaintiff can prove both those two things. And they say here, it loses. They say the general rule prevails. Why? Because the presumption is generally applicable. And here, FanDuel has considerable contacts with Scotland. They founded it there. They registered it there. It's referenced in the Articles of Incorporation. They maintain offices there. And the plurality of the plaintiffs live there. And as to number two, whether there's a dominant interest of New York, they say New York does not have a dominant interest in applying its own law. Though its principal office is in New York, and though it holds board meetings here, only 10 to 15% of the total revenue comes from New York. So at this point, because that fails, the general presumption still applies, Scotland law applies. So the Scottish law will apply substantively to this case. But they say applying Scottish law, this is cognizable. There is a possibility, it's possible inference that special circumstances are present that rises to a cognizable fiduciary duty claim under Scots law. So they say, even applying Scots law as they wish us to do, the case is not dismissed because under Scottish law, the plaintiffs here can theoretically have a case. So the motion to dismiss is denied, and that's the case of Eccles versus Shamrock. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.